I'm Barry Ritholtz. You're listening to Masters in Business on Bloomberg Radio. Today, I have an extra special guest. His name is Neal Katyal. He is the former Solicitor General of the United States for the Obama administration. He is a legendary appellate attorney. He has argued more cases in front of the Supreme Court than I want to say any living attorney these days. He's currently a partner at Milbank, where he's a member of the firm's litigation and arbitration group. He pretty much has won every award there is to win as an appellate litigator. He is a recipient of the highest civilian award by the U.S. Department of Justice. The Chief Justice of the Supreme Court appointed him multiple times to the Advisory Committee on Federal Appellate Rules. He's been named Litigator of the Year, top 50 lawyers, most influential lawyers in D.C. On and on it goes. Rather than just read you his CV, let me say, Neal Katyal, welcome to Bloomberg.
Thank you. It's a pleasure to be with you.
Well, it's a pleasure to have you. You couldn't possibly be more relevant to this moment in time with what's going on in terms of policy and politics and jurisprudence. But before we get to that, let's spend a little time just talking about your background and career. Dartmouth undergrad, JD from Yale. What was the original career plan?
The original plan was for me to be a professor of history.
Really?
And I went to Dartmouth College, as you noted. I probably was one of the last kids admitted to Dartmouth. I was not a particularly great high school student. And I had this professor, Doug Haynes, in history at Dartmouth, who basically taught me to write and taught me how to think. And I was so grateful to him, and I felt like I should do that with my life, is go and give back in the way that Doug had given me this incredible gift. And so in my senior year, I say to Doug, I ask him to have lunch with me, and I say, I'd really like to be a history professor. And frankly, you're the one who inspired me, and I want to do this. And he thought about it, and he said, honestly, Neal, I don't think you should be a history professor because it's really tough and it's hard to get tenure, and you'll have to start in some, small town in the middle of nowhere. It's hard to meet a spouse and so on. He said, look, at that point, I was a national champion debater. And he said, my advice to you is to go to law school. And in particular, he said, go to Yale Law School, which is known for creating law professors. And you can do all the same stuff you want to do, but as a law professor, where you would get paid 3 times, it's easier to get tenure, your life is a lot easier. So I did that. I applied to Yale Law School. I got in. Again, probably one of the last kids admitted. And at the law school, I had these incredible professors who did the same thing that Doug Haynes did for me in history in other areas, constitutional law and criminal law and the like. And these incredible professors who taught me, again, how to think and how to write. And so I was committed to being a law professor. I clerked first for Guido Calabresi, who was the dean of the Yale Law School, who was put on the Court of Appeals, and then for Justice Stephen Breyer. But all through that time, I knew I wanted to be a law professor. So I applied while I was clerking to teach. And at the age of, I think, 26 years old, I took a job teaching at Georgetown Law. And that was the plan for my life, to be a law professor and nothing but a law professor.
And do you still do any teaching these days?
I do, and I love it. And in many ways, it's my favorite job I've ever had. But there's a lot else going on in the world these days. And so, it was a little bit by accident that I fell into this litigation thing. Yes, I was a national champion debater, and so I was comfortable being on my feet. But I was really, my dominant thinking was be a law professor, write these theoretical articles that change the way people think about the law, and teach students. So that's what I thought I was going to do. And then something happened, which was we had the horrific attacks on September 11th, and I was bumbling around trying to figure out what to do. I was teaching at Yale Law School that year, and my students and I, we decided to try and help first responders get benefits and stuff, and we weren't particularly good at it, but it was something. And then President Bush announced that he was going to have these military trials at Guantanamo Bay for suspected terrorists. And I looked at that. I'd served in the Justice Department briefly, and we had the embassy bombings of al-Qaeda at the time. And so I looked into, could we have military trials? And we concluded they were obviously unconstitutional. So I went and looked up, what's President Bush doing here? What's his source of authority for this? And, it wasn't particularly compelling. In fact, it was really weak. Because the president was saying he was going to set up these trials from scratch. He was going to pick the prosecutors, pick the defense attorneys, write all the rules for the criminal trials, define the punishments and offenses, including the death penalty.
Seems even-handed and fair.
Right.
What's your objection?
Yeah. And, and even the last lines of the executive order said the courts have no business reviewing what I'm doing. There's no writ of habeas corpus. So I went into my constitutional law class and said, you guys always tease me because I think the president should have such strong powers and nothing the president does is unconstitutional. Well, here's something that's obviously unconstitutional. And in the class was a staffer for Senator Leahy, who was then the chair of the Senate Judiciary Committee. And so she told him about me, and he had a hearing, and I testified and said, look, I don't know if you want to have these military trials or not, but the one thing I'm sure of is that it can't be done with the president's stroke of his pen. You need Congress to approve it. And this is, of course, going to be relevant as we talk about tariffs later. It's the exact same architecture of the argument. And so that's how I testified. Nobody listened. So then I go and I write a law review article with Lawrence Tribe, the nation's most preeminent constitutional law professor. So you at Yale,
Lawrence at Tribe at Harvard.
Yeah, exactly. And so we write this article in the Yale Law Journal. We race it to print saying what's going on is unconstitutional. Nobody reads the article. Maybe my mom read it, but, I don't know. So then I said to myself, you've got this piece of paper, Neal, a law degree. You could actually sue the president. And
well,
that's
you needed
a
plaintiff, though, don't you?
Exactly. So that was the hard question, because a bunch of different interest groups had sued on Guantanamo, but they didn't have standing. They had no reason. And so I had a friend very high up at the Pentagon who got me the email address of a Pentagon lawyer who was representing the detainees. And I basically got a letter snuck to Guantanamo, and it wound up in the hands of Osama bin Laden's driver, and that became my client. And so I go from being a theoretical law professor to like a real, hard-nosed litigator, all in the span of a few months. I filed the case. Nobody thinks we're going to win.
How far are you from law school now?
I'm like 6 years out.
So still relatively green.
Yeah, very green, and never filed a lawsuit, And so, by the way, I don't have any help except 4 law students who are helping me. I tried with law firms, and initially I couldn't get them, but then ultimately Perkins Coie, a Seattle firm, decided to help me, and that was phenomenal. So we filed this thing. Nobody thinks we're going to win. And we win it in the trial court. We lose it in the Court of Appeals with a guy named John Roberts on the dissent panel. 3 days later, he's nominated to the Supreme Court and then to the Chief Justiceship. So I have to ask the Supreme Court to hear this Guantanamo case. It's the most important case their new Chief Justice has ever decided. And I'm going to say, I'm trying to tell the Supreme Court the Chief Justice is wrong about this. Nobody thinks we're going to win. It's my first Supreme Court argument. I'm arguing against President Bush's legendary Solicitor General. It's his 35th argument. I work my tail off, and we win. And then my life changes. And then companies want to hire me. And I meet a young senator named Barack Obama who heard me interviewed on an interview just like this one. And he calls me into the Senate and says, ask me to advise him on some things on Guantanamo, and tells me he's thinking of running for president. And then started working with him. And then my life changes massively.
Wow. That's amazing. I want to talk about a couple of the other cases that you argued. One was Moore versus Harper, which former Judge Michael Luddick called the most important case for American democracy ever. Tell us about that case.
Yeah, so that's a pretty recent one. I argued it, I think, about 3 years ago. And it involved something called the independent state legislature theory, which at that point was the greatest threat to democracy. I think when Judge Ludwig was writing those remarks, we've now had some things which, are arguably worse. But it was a significant one, because if you think back to the 2020 election, one of the things that President Trump tried to do then was to say that state legislatures can control elections, and you can even throw out the popular vote and just have state legislatures decide where the electoral votes will go to which candidate. And this became part of the RNC's playbook, and they invested heavily in state legislatures to try and develop, this theory. So we challenged that. Again, this is one in which nobody thought we could win, because if the Republicans won, they would entrench control over presidential elections for decades, probably. And a lot of people think, oh, this Supreme Court, they're appointed by Republicans, they're very conservative, they're just going to do the Republican Party's bidding. And I looked at it and I said, I don't think that's right. I mean, this is a court that does have fidelity to the original understanding of the Constitution. And I thought, if we could make the argument in that way, and this is what my scholarship is all about, the original understanding of the Constitution, I said I thought we could win. And so that's what I developed as the strategy. And indeed, I knew that Justice Clarence Thomas, would ask the first question at oral argument. That's been happening now for the last few years.
Just out of habit, or like how does that
Well,
come
he's
up?
one of the more senior justices. And during COVID, when we had to argue cases on speakerphones and we couldn't see each other, it went in order of seniority. And so Justice Thomas was right at the top. After COVID, that tradition continued in which Justice Thomas would ask the first question. And so I'd been thinking, how do I use that knowledge to my advantage? Justice Thomas is going to ask the first question. And what I did was I said to myself, okay, I can develop a set play. Justice Thomas is going to ask me a question. Doesn't matter what the question is. I'm then going to say, and this is what I do. Justice Thomas asked me a question at the argument. I don't remember what the question was. I answer it, and then I say, Justice Thomas, may I say, in nearly 3 decades of arguing before you, I've been waiting for this case because it speaks to your method of constitutional interpretation, the original understanding. And here are the 4 things you need to know about Moore versus Harper in the original understanding of the Constitution. And I get to talk about Madison and Hamilton and Jefferson and so on. And it totally changes the dynamic in the courtroom. And sure enough, we win 6-3 this case, and the Republican theory is thrown out. I didn't win Justice Thomas's vote, but I won a bunch of others.
Huh, that's amazing. Let's quickly talk about the Voting Rights Act that you successfully defended instead of trying to overturn it. Tell us how different it is to be playing defense, or is it not? You're just arguing Constitution and law, and this is the outcome that should come about.
It is different, but I would say even back then I felt like I was playing defense. So this was a case I argued in maybe 2010. The Voting Rights Act had been passed in 1965. It literally has the blood of patriots on it. It is what Selma and the bridge, Patea's Bridge, is all about. And in the case, basically, it was right after President Obama had been elected. And southern states said, look, we don't need the Voting Rights Act anymore. Look, you have an African-American president. Like, that's proof that we don't need it. And I stood up in court and said, no, we do need it. And it's like, the very fact that we've been able to have an African-American president isn't alone enough to say there isn't discrimination in voting, particularly in particular areas, even if the overall national result is one thing. And the Supreme Court at that point accepted that argument. And 4 years later, however, in a case called Shelby County, they reversed that position and struck down that part of the Voting Rights Act. And now there's only one part of the Voting Rights Act that remains, Section 2, and the Supreme Court's agreed to hear a case to challenge that this fall. And so we very well may have a world in which there is no Voting Rights Act left whatsoever, which is a very dangerous thing. And yes, I do think the court has become more conservative over my lifetime. I mean, the court has always been majority Republican appointees since, I think, 1972.
So this isn't just partisanship. This is an ideological tilt, not necessarily a party tilt?
Yeah, so I would say, that the presidents now of both parties are sending to the Supreme Court more sure things. Mm-hmm. In which the track record is really known. The Republicans had this mantra, no more suitors, because mm-hmm. David Souter, nominated by Republican President Bush, upheld things like abortion rights and so on. And the Democrats, I think, have had their own version of this for some time as well. And so we don't tend to get justices without very defined positions anymore. Like when I started arguing, Justice Kennedy was on the court, and you could see, Barry, every time you argued, he was struggling with which is the right which is the right view of the law. And he's a very smart man. It wasn't that he wasn't smart. When I say struggling, it's not that he was struggling intellectually.
They were pretty even-handed arguments on both sides.
Yeah, and he really took the arguments so seriously without caricaturing them and just tried to make the right decision. And certainly that still happens today. I don't mean to overclaim it, but I would say in particularly some of the big cases, they're coming in a bit more with their minds made up than when I first started.
After we recorded our conversation, a federal's appeals court ruled on Friday that many of President Trump's most punishing tariffs were illegal. Neal and I spoke again after that ruling. He represented the small businesses that brought the case. First off, Neal, congratulations. You just won a major appellate case in VOS elections versus Donald Trump. So congrats.
Thank you so much. Yeah, I think I saw you and we had our interview the day before the decision came down. The way the Court of Appeals works, like the U.S. Supreme Court, they never tell you in advance when a decision's coming down. And indeed, it was a little, I think, past 5 o'clock on Friday, right before Labor Day, and I was about to leave the office, and then I heard my email ding, and I look at it, and I'm like, well, I might as well see what this is. I assumed it was just some, minor thing. And they're like, whoa, it's the decision. And, Barry, they let me know the decision at the very same time they let the world know, because otherwise, if they let me know in advance, that's private information. This is the kind of information that does move markets. And so they let the entire world know, including me, at the very same time.
So let's put this into a little timeline. We had our recording Wednesday, August 27th. The decision dropped around 5 o'clock on Friday, August 29th. Today is Sunday, August 31st. Everybody else is on the beach. I know you're leaving for Europe in a couple of days, but I wanted to just touch base with you and try and figure out where this goes from here. So let's start out with the decision. I thought the majority decision, 7-4 your way, I thought it was a pretty powerful refutation of the executive's ability to just impose tariffs. I don't want to say on a whim, but lacking the specific following of the IEEPA rules and what an emergency actually is. Can you address that a little bit?
Yeah, I think that the 7 judges in the majority were saying exactly what we've said all along, which is maybe these tariffs are a good idea, maybe they're a bad idea, but they can't be imposed by the president's pen alone. You got to go to Congress and get that authorization. That's our constitutional system. And what the 7 judges said is that's exactly right, that the Congress has never given the president such a sweeping power to just do it on his own. And if they did, they said it'd be unconstitutional. But they said that isn't what's going on here. And the president has an easy fix. If he wants to, he could go to Congress and seek approval for the tariffs that he wants. That's what he did the first time around. And as we talked about last week, that's something that failed in Congress. And so maybe that's why he doesn't want to do it. Obviously, these tariffs are highly unpopular. But nonetheless, the Congress is controlled by his party. And that's the place to start. Don't run to the federal courts to do what you can't do in Congress.
So I want to talk about the dissent in a bit, but let's just talk about what the appellate court did, which I was somewhat confused by. Maybe you can clarify this. They remanded back to the International Court of Trade in DC, which is a U.S. Court, for findings about who this applies to. Like, it seems sort of odd to say, well, it only might apply to the litigants. What are we going to have? 7 million cases on this tariffs? It would seem that either it's constitutional or unconstitutional, and that applies to everybody, or am I being naive?
I think that's basically right, Barry, that I think ultimately the question is, are these tariffs legal or illegal? If, as the Court of Appeals said, they're illegal, then the vast, vast majority of Trump's tariffs are unconstitutional, illegal, can't be imposed, and people who've had them imposed, may have remedies and recourses. What the court also did, though, and you're referring to a fairly technical part of the decision, is it sent a case back to the lower court to evaluate the scope of the remedies. And that's because the U.S. Supreme Court, just very recently in the birthright citizenship case, has announced some new ways of thinking about relief on parties, in particular in class actions and things like that. And so I think the Federal Circuit did the prudent thing here by just saying, with respect to that, we'd like the lower court to evaluate it. I think that's pretty much a sideshow at this point. My strong hunch is that the federal government has a strong interest in resolving this question. After all, this is a really, an initiative of President Trump's that's been declared unconstitutional. So I think they're going to go to the Supreme Court. I mean, again, I wish that weren't the case. I wish they'd go to Congress, which is the way that our Constitution commands things. But according to the president's tweets and the like, they want to go to the Supreme Court.
So what is the process like for this to go up to SCOTUS? First, the remand back to the district court, not relevant. That's just a very specific remedy question. Assuming the petition for certiorari is filed by the government, what are the options? What might the Supreme Court do?
Yeah, so I think you're right to say that the lower court proceedings on relief are irrelevant here. Indeed, the Federal Circuit said that lower court has no role, at least until October 14th, because they wanted to give the government time to file what's called a petition for certiorari, which is a formal request to the U.S. Supreme Court to hear the case. The government is saying that in these tweets by the president and others, that they will file that petition for certiorari, ask the Supreme Court to hear the case. And then it's obviously up to the Supreme Court to decide. Statistically, when the government asks them to hear a case, particularly in one that has important consequences, the court does hear the case. So the court very well may set the case for oral argument, and then there'll be the argument from the two sides as to whether or not this lower court decision that we won, declaring President Trump's tariffs unconstitutional, whether that will be upheld by the U.S. Supreme Court.
So I was kind of intrigued by the dissents, which I'm not a practicing attorney anymore, so I'm not up to date in what is the latest thinking in terms of art. But it sort of seemed like one of the dissents suggested that it's an emergency if the president declares it an emergency. Kind of makes that word meaningless. How did you read the significance of the dissent, and what might it mean to the hearing if this ultimately goes to the Supreme Court?
I think that's exactly right, what you're saying, which is if the dissent were right, it basically reads the word emergency out of the statute. It gives carte blanche deference to the president. And the Supreme Court, in an earlier case back in 1911, said you can't do that with the word emergency. And here, I think, Barry, the other really important point is that the law that the president is citing, IEPA, doesn't just talk about emergency, it requires it to be unusual and extraordinary. And the president's own executive order, when he imposed these tariffs, said that the trade deficits were persistent and gone on for 50 years. They're the opposite of unusual and extraordinary. And look, of course, you want the president in a genuine, true emergency that's unusual and extraordinary to have extra powers, because if Congress can't meet to repel some threat or something like that, you want the president to have some gap-filling power. This is the opposite of that. I mean, Congress is in session, they're passing bill after bill and the like, and of course, they're controlled by the same political party as the president. So the idea that Congress can't act is, to use the technical legal term, poppycock.
All right, so let's broaden this out a little bit. I think this is an important case because I'm a market participant, and tariffs are a tax, they're a headwind to consumer spending and other economic activities. But stepping back and looking at this from a constitutional standard, how much of this is focusing on how much authority the executive branch of the U.S. government has? Is this an attempt to rebalance the three parts of government by this particular president? Or is this just, no, we want our tariffs and we want to stop all these bad things that the tariffs will cure?
Yeah, I view this decision not as a rebalancing of our constitutional separation of powers, but rather a return to what our founders' original concept was, which was Congress makes the laws, the president enforces them, the courts decide whether those laws are legal or not. And here, what happened is you had a president who colored well outside of the lines, and asserted an extraordinary power that no president in American history has ever asserted on his own. And I think the court is doing here what the courts have done time immemorial in other cases, whether it was the seizure of the steel mills by President Truman in 1952, whether it was President Bush's law-free zone at Guantanamo after the horrific 9/11 attacks, whether it was President Biden's student loan initiative programs. In all of these cases, you've had presidents that try and assert muscular powers, and the court pushes back on them. And this is, I think, a pretty extreme illustration of a president who's asserting powers that he has no business asserting.
So at the appellate level, it was 7-4. The dissent was written by a justice appointed by President Obama. It's kind of a little bit surprising to me. When you look at the lay of the Supreme Court, I know a lot of people tend to look at that as Democrats versus Republicans, but the appellate attorneys I know and the people who are constitutional lawyers tend to look at it as originalists versus more modern interpreters. How are you looking at this case when it gets, assuming it goes up to the Supreme Court? How are you looking at the context of this case?
I love the question because, oftentimes people say things like, well, the Supreme Court is appointed by Republicans, so they only wrote Republican or nonsense like that. That's just not my experience. I mean, I've been lucky to argue 52 cases there, and I just don't see it in the same way as those kind of pundits see it. And, I think you're right to say the decision by the 7-4 court's a good illustration of that. The dissent written by a judge who was appointed by a Democratic president. Our majority opinion, the senior most judge in the majority, is Judge Lori, who was appointed by President Bush, but says that these tariffs are unconstitutional. So I don't think it's the right way to think about it. I think that there are people who take constitutional limits more seriously and others who want to defer and avoid getting the courts in the middle of something. And so maybe that's one axis that sometimes could be used to predict outcomes. But here, I think no matter which way you look at it, the president just doesn't have this power. We might wish he had this power. It might be a good idea for him to have this power. But our founders were as clear as day in Article 1, Section 8. They said specifically the power over duties is one given to the Congress, not to the president.
So there are a couple of key issues this is going to turn on. The constitutionality, Article 1, Section 8, the IEPA laws, and what is an emergency. Any other factors that might drive this that we should be aware of?
Yeah, I think there's a couple. One is that the Supreme Court in recent years has announced something called the Major Questions Doctrine. And the idea of that doctrine is to say if Congress is giving the president some sort of power, they don't hide it in vague terms. They say it really expressly and clearly. Justice Scalia's phrase is that Congress doesn't hide elephants in mouse holes. And at the oral argument, I took that to even further. I said, this isn't just an elephant in a mouse hole, it's a galaxy in a keyhole. It's an extraordinary set of powers given to the president, that claimed by the president. And, this doctrine, Major Questions Doctrine, has been used, Barry, by the US Supreme Court repeatedly to strike down President Biden's initiatives, whether it's over greenhouse gases or whether it's over student loans or whether it was over COVID eviction moratoriums and things like that. And I think that, what the majority said in this opinion that we won just a couple days ago is, hey, what's sauce for the goose is sauce for the gander. This applies to other presidential initiatives, and including, of course, this one here, and that it would be a violation of the Major Questions Doctrine for Congress to have not even used the word tariff or duty or anything like that in IEPA, and then to have a president come along and say, ha, I can now do whatever I want.
So let's expand this a bit. How creative
was it of the administration to try and get tariffs imposed under IEEPA? Is this something that's just wildly outside of what IEEPA originally was designed about?
100%. Nobody, and I've read the legislative history behind IEPA very carefully. Nobody thought that this was about the tariff power. And so, yes, they get A plus plus for creativity, the Trump administration, in coming up with an argument that not only no one in Congress thought, no president for 50 years has thought. Now, creativity only gets you so far because you have to be at least somewhat faithful and accurate to the original text and meaning of the law. And that's where I think, unfortunately, they get an F and they fall down on the job.
So I have a pretty solid recollection of sitting in constitutional law classes and occasionally seeing a decision that was just perplexing. Although when you're looking at something that's a century old, a Dred Scott or a separate but equal type of decision, obviously you're bringing a modern perspective. It's very hard to see outside of that. I had the same, you and I spoke before we had the decision come down. I was kind of perplexed that this was even like a debate. It seems pretty obvious. None of the normal rules for enacting tariffs, none of the procedures, policies, or allocation of powers amongst branches of government was followed. So what do you imagine the government's argument is going to be at the Supreme Court level?
Right. So, Barry, I think the secret about Supreme Court and presidential power advocacy is this. I mean, no matter how creative and ridiculous the argument is, if the president voices it, it's a court case and it's going to be taken seriously by everyone because it's, after all, the president. Sure. And that's why, when I was the president's top lawyer, courtroom lawyer, I was very careful to only make the arguments that I thought had very strong basis behind them, because you don't want to diminish that credibility that the government has with the U.S. Supreme Court. Here, I do think that the arguments are quite a stretch for the administration to be making. And I think, that's what you saw reflected in the 7-4 opinion. So what do I think that the Solicitor General is going to say to the Supreme Court? I think he's going to say what he's been saying all along. The president says he needs this power. It'd be dangerous to unwind all of these deals and present it as a fait accompli. And I just think that's the wrong way to think about constitutional law, to allow a president to do what he wants in the interim and then say, oh, it'd be too dangerous to unwind it. I think it's better to get the constitutional rules right the first time.
So some of the arguments I've seen from the administration is not only are the tariffs complicated and we've spent all this time and effort negotiating them, which this would negate, but it would be a negative for the global economy. You will cause economic distress around the world if you throw these tariffs out. Seems like a little bit of a histrionic claim.
Well, I have two things to say about that, and we can defer to the president about whether the claim is right or wrong, whether it's histrionic or the like. Let's just say it's right. Two things. One, if that's right, it walks right into the constitutional problem, which is the major questions doctrine, right? If the administration is saying, oh, the economy is going to collapse without these things, that's exactly the kind of major question that you think Congress has to decide, not the president, number one. And number two, if it isn't histrionic, if it's really right that the economy is going to collapse, then it's the easiest thing in the world for the president to go to Congress and seek authorization. I mean, I don't think the Congress wants the U.S. economy to collapse, and there are, of course, members of his own political party that are running Congress. So there's not even a politics barrier or anything like that.
Thank you, Neal, for being so generous with your time. We have been speaking with Neal Katyal. He is the appellate litigator for VOS Selections versus Trump, which seeks to declare the president's tariffs not only null and void, but unconstitutional. If you enjoy this conversation, well, check out any of the other 500 we've done over the past 12 years. You can find those at iTunes, Spotify, Bloomberg, YouTube, wherever you find your favorite podcasts. I would be remiss if I did not thank the crack team that helps us put these conversations together each week. Alexis Noriega is my producer. Sage Bauman is the head of podcasts at Bloomberg. Sean Russo is my researcher. I'm Barry Ritholtz. You've been listening to Masters in Business on Bloomberg Radio.